Nigerians are not unaware of the criminal matter concerning the presidential candidate of the All Progressives Congress, Asiwaju Bola Tinubu, in respect of his criminal conviction and sentencing by a court of competent jurisdiction in the United States of America over a criminal case of trafficking in narcotics for which Tinubu forfeited a humongous sum of $460,000 to the states. For the avoidance of doubt, the United States Court, in sentencing Asiwaju Tinubu, ordered that the funds in the amount of $460,000 in account 263226700 held by First Heritage Bank in the name of Bola Tinubu represent proceeds of narcotics trafficking or were involved in financial transactions in violation of 18 U.S.C. S. 1956 and 1957, and therefore these funds are forfeited to the United States pursuant to 21 U.S.C. S. 881, subsection A and subsection C, and 18 U.S.C. S. 981. This is the ruling. That was the judgment. From the declaration of the court and the sentencing, it is clear that Asiwaju Tinubu was summarily convicted by the court. He took no step to challenge the judgment, but he acceded to the forfeiture of the $460,000 found to be proceeds of narcotic trafficking. It is already established that trafficking in narcotics is an international crime, which all nations are obligated by international conventions and statutes to arrest, prosecute, and implement any court judgment imposed on offender anywhere in the world, as well as the consequential effects of such judgments. As we are all aware, Nigeria is a signatory to such international conventions and therefore is mandatorily obligated to implement the consequential effect of the conviction imposed on Asiwaju Tinubu by a court of competent jurisdiction in the criminal case of trafficking in narcotics. You will further recall that as our great party, the People's Democratic Party, had already established the presidential candidate of the APC, having been convicted and having acceded to be guilty as charged by way of forfeiture of the $460,000. Nigeria, being a signatory to international convention, is mandatorily obligated to execute the consequential effect of that conviction, as also provided by virtue of Section 137, subsection 1, subsection D of the 1999 Constitution as amended. For clarity, Section 137(1)D of the 1999 Constitution as amended provides that 1. A person shall not be qualified for election to the office of president if, subsection D, he is under a sentence of death imposed by any competent court of law or tribunal in Nigeria, or a sentence of imprisonment or fine for any offense involving dishonesty or fraud by whatsoever name called, or for any other offense imposed on him by any court, any other offense imposed on him by any court or tribunal, or substituted by a competent authority for any other sentence imposed on him by such a court or tribunal. The import of the foregoing is that under the 1999 Constitution, as amended, having been so convicted and fined, and having acceded to the sentencing by way of forfeiture of $460,000, and having not received any state pardon or acquitted by any court of competent jurisdiction, Asiwaju Tinubu remains a convict, and the consequential effect is that he cannot contest election at any level in Nigeria. The consequential effect is that the listing of the name of Bola Tinubu, who stands convicted by a court of competent jurisdiction on the ballot for the 2023 presidential election, is by virtue of Section 137, subsection 1D of the 1999 Constitution as amended, fundamentally illegal, invalid, and must be expunged immediately. Consequently, our campaign has proceeded to the court, demanding the court to declare Bola Tinubu, the presidential candidate of the APC, having been convicted as ineligible to contest the presidential election by virtue of Section 137 1D of the 1999 Constitution as amended. 2. To ask the court to compel the INEC, the Independent National Electoral Commission, to immediately delist Tinubu as a presidential candidate of the APC or any other political party for that matter, and expunge his name from all materials and documents related to the 2023 presidential election. Our campaign will be filing for accelerated hearing, in this case, in the interest of our nation, as our laws do not permit a convict, let alone an individual convicted on account of international crime of trafficking in narcotics, to stand election at any level. Nigeria cannot afford the embarrassment of having a convict hold office at any level against our laws. The Atiku Kowa campaign cancels all those wasting their funds, time and energy on the APC presidential candidate, Bola Tinubu, to put their resources to better use, as his gap-infested showboating presidential ambition has practically come to the end of the road. Thank you for listening. Any questions, please?